Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Well, thank you and good morning, everybody. Happy holidays to you. And welcome to the December 14th, 2020 meeting of the Hillsborough County Land Use Hearing Officer. My name is James Scarola, and I'm going to be the hearing officer this morning. What we'll do to get things moving today is a little bit of procedure first. We're going to go through our agenda, see if there's any changes. And after that, I'll do a quick set of procedures with you on how we'll conduct the hearing, and then we'll move right on into it. So with that in mind, I'd like to introduce you to Mr. Tom Hisney of the Development Services Department. Good morning, Tom.
Good morning, Mr. Scarola. To my left, we have Carmen Mason of Development Services. We'll also be joined during the hearing by various staff members virtually and in person. With this meeting, we're also joined by Cameron Clark of the County Attorney's Office. We have one change to the agenda, and that is page 8. Item H2, Special Use Application 20-1234. The applicant is Min Feng Louis. This application is being continued by staff to the January 2021 Land Use Hearing Officer meeting. The agenda said that it was going forward today, and then also the blurb said it was out of order when in fact it's being continued by staff, and I have a revised blurb to be handed out to you and the clerk.
Okay. But Tom, just to be clear for the audience, that's agenda item H2, and that's going to be continued to
that's
January
being continued to the January 25th, 2020 Land Use Hearing Officer meeting at 10 a.m. And it was a staff continuance. It was not out of order.
Page 8, everybody. At the top of page 8.
Right.
Thank you, Tom.
Right. Thank you. All right. So here are the published continuances and withdrawals as follows. Item A1, Variance Application 20-0244. The applicant is Russell Capel. This application is out of order to be heard and is being continued to the January 25th, 2021 Land Use Hearing Officer meeting. Item A2, Variance Application 20-0317. The applicant is John Schuman. This application is out of order to be heard and is being continued to the January 25th, 2021 Land Use Hearing Officer meeting. Item A3, Variance Application 20-0352. Applicant Michael Simaluka and Cynthia Fernandez. This application has been withdrawn by the petitioner. Item A4, Variance Application 20-0398. The applicant is Eloy Martinez. This application is being continued by staff to the January 25th, 2021 Land Use Hearing Officer meeting. Item A5, Variance Application 20-0496. The applicant is Abby Feely. This application is being continued by staff to the January 25th, 2021 Land Use Hearing Officer meeting. Item A6, Variance Application 20-0992. The applicant is April and Jason Foreman. This application has been withdrawn by the petitioner. Item A7, Special Use Application 20-1017. The applicant is TSP Companies Incorporated. This application is out of order to be heard and is being continued to the January 25th, 2021 Land Use Hearing Officer meeting. Item A8, Variance Application 20-1088. The applicant is Francisco Otero Casio. This application is being continued by staff to the January 25th, 2021 Land Use Hearing Officer meeting. Item A9, Variance Application 20-1284. The applicant is Divi Sardu. This application is out of order to be heard and is being continued to the January 25th, 2021 Land Use Hearing Officer meeting. Item A10, Variance Application 21-0001. The applicant is Maribel and Louis Marchand. This application is out of order to be heard and is being continued to the January 25th, 2021 Land Use Hearing Officer meeting. Item A11, Special Use Application 21-0003. The applicant is Denise Donaldson and Alan Jones. This application is out of order to be heard and is being continued to the January 25th, 2020 one land use hearing officer meeting. Item 812, special use application 21-0013. The applicant is Waverly Realty LLC. This application is out of order to be heard and is being continued to the January 25th, 2021 land use hearing officer meeting. And finally, item A13, variance application 21-0022. Applicant is Eliezer Seymour Martinez. This application is out of order to be heard and is being continued to the January 25th, 2021 land use hearing officer meeting.
Okay, thank you, Mr. Hisney. And ladies and gentlemen, you can see all of that on page 4 of your agenda if you are interested. Now, with respect to our hearing procedures, the hearing today is generally going to be informal. Questioning will be confined as closely as possible to the scope of direct testimony. And what that means simply is when you come forward, you'll just be speaking to me. As the hearing officer, I'll call and question witnesses as necessary and appropriate, and I'll be deciding all questions on procedure. Irrelevant, immaterial, or unduly repetitious evidence is going to be excluded. Any part of your evidence may be received in written form, but all of your testimony today is going to be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but it won't be sufficient in itself to support a finding unless it would be admissible over objections in a civil action. So having said that, the basic procedure today is going to be as follows. First, the Development Services Department, after a brief introduction of each petition by Mr. Hisney, will be able to present the county staff departmental findings, and they'll have a period of about 5 minutes to do that. I'll then ask for the applicant and any of their witnesses to come forward, and you will have up to a maximum of 15 minutes to present the application and any of the supporting evidence or testimony. I'll then turn and ask if there's any proponents. Proponents are not representatives of the applicant again. Instead, they are other parties who might be supporting the petition, and there'll be a time segment of up to 15 minutes set aside for any proponents. I'll then ask for any opponents. If there's anybody in opposition, please, by all means, if there's more than one of you, get together and try to split up your time as necessary or designate it to somebody, but also a similar time segment of 15 minutes for opposing testimony or evidence. I'll then ask staff if there's any changes based on the testimony. And lastly, the applicant has the opportunity for a final rebuttal, and that's for a period of 5 minutes. So by the way, those timeframes are simply those designated in the Land Development Code, and that is your right, but don't feel the need to fill the time. I, of course, have your applications and everything that you submitted with it. And any other supporting testimony or evidence, well, you're welcome to give it today. Couple of tips for you when you come forward. Step up to this microphone that's in front of me on this podium, and always say your name and your address first when you first go to speak. Name and address first, and that's because we're establishing a record here, and the record needs to indicate who's speaking. If for whatever reasons you end up having to be seated, and then there's a reason for you to come back forward again, no need to repeat your address, but there's always a need to repeat your name. If you come back up to the microphone, just repeat your name. Always speak clearly into that microphone, which means it's a good idea to pull it down close to your mouth when you go to speak the first time. And when you're all done, to my right, there's a sign-in sheet. So go from the podium to the sign-in sheet and sign in, and that will conclude your presentation of any testimony or evidence submittal. So we also have our assistant county attorney online and available, and that county attorney is going to supply information to you about appealing decisions that are made as a result of today's hearing. So good morning.
Good morning. This is Mary Dorman from the County Attorney's Office. I'm on the meeting today, or the hearing today, in addition to Cameron Clark. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It's the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Appeals Board.
Ms. Dorman, and by the way, welcome to the hearing. So, ladies and gentlemen, if you plan on giving any testimony or evidence today, I'd like you to rise with me now and raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Thank you.
All right. With those formalities aside, I think we're ready for our first petition, Tom.
All right, so on today's agenda, we have no vested rights cases, no fee waiver requests, no reconsideration requests. So that'll take us to section E of the agenda, site development.
Tom, excuse me. I had one technical item I wanted to get taken care of. If you'll give me just 1 second.
Sure.
I happen to notice, and if there's anybody with information or if this person is here, I just want to make sure somebody is not waiting for no good reason. There's a recent update to the form stack list of people intending to speak. And one of those people who signed up in person placed the petition number Major Mod MM 20-0377. The person's name is Robert Drummer. And that is not on this land use hearing officer agenda today. Is Mr. Drummer here? Okay, again, the intention is to not have somebody waiting when there's no good reason to wait. All right, thank you, Tom.
You're welcome, sir. All right, so again, we go to section E of our agenda, site development variance requests. The first case is item E1. Variance Application 20-1297. The applicant is Thomas Andrew Hobson II. The request is a variance to encroach into the wetland conservation area setback. Staff findings will be presented by Carla Shelton.
Good morning. This is Carla Shelton with Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on September 28, 2020, is to allow for placement of a fence within the 30-foot wetland conservation area setback. Per the Land Development Code, section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot conservation area setback. The applicant requests construction of an aluminum rail fence within the 30-foot wetland conservation area setback up to the wetland line. The applicant requests a 30-foot reduction of the setback to allow for a setback of 0 feet. That's all I have for right now.
Thank you for that, Carla. Is the applicant here on variance 20-1297? Yes, sir. Come on up. Good morning.
Good morning. Good morning. My name is Thomas Hobson, and my address is 18019 Pine Hammock Boulevard, Lutz, Florida, 33548.
Go ahead, sir.
Okay, so essentially what I'm requesting to do is my property backs up to conservation land, and there's a wetland conservation setback 30 feet that is included in my property boundary. And I would like to fence my outside of my property line, which would butt up against the wetland conservation setback area. I'm looking to fence it in a way that will not obstruct the flow of water or any type of pitch to the land. I just would like to be able to fence my property line. That's essentially it.
Okay. I guess the only question I had, and I did go through it, is your rear property line is the boundary of the conservation area?
Yes, sir.
Okay, so that's coincident. And then 30 feet in from that is the wetland area setback line.
Correct.
Okay. Anything else, sir?
I have just a couple of emails from folks that supported my request, my neighbors, if you'd like those.
So you have them in writing?
I do.
Okay, if you would hand them to the clerk and also sign in there.
Okay.
Okay?
That's it?
Yes, sir. Thank you for your testimony. Okay, is there anybody here today in support of this request? Okay, seeing none, is there any opposition to this request? Nope. All right, with that, I'm going to close variance 20-1297.
Our next item is E2, Variance Application 20-1373. The applicant is S&ME Incorporated. Request is a variance to encroach into the wetland conservation area setback. Staff findings will be presented by Carla Shelton.
Good morning, this is Carla Shelton with Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on October 14, 2020, is to allow for construction of a portion of a structure, driveway, dumpster pad, sidewalk, and pond within the 30-foot wetland conservation area setback. Summary per LDC section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of 873.8 square feet of impervious surfaces and an undetermined square footage of pervious retention pond area within the 30-foot wetland conservation area setback. The applicant requests a 15.5-foot reduction of the setback to allow for a setback of 14.5 feet. Staff findings: the amount of proposed encroachment will require the submittal of a wetland setback compensation planting plan. This plan will be required to be submitted and reviewed with the construction plans for the project known as Bloomingdale Avenue site, project ID number 5434, in the county's site plan review process.
Carla, quick question for you. So it's summarized by saying that there's a 15.5-foot reduction requested to allow a setback of 14.5, but that proposed pond in cross section B looks like it takes up the whole wetland setback. I get the impression that that was really intended to the 15.5-foot reduction was intended to apply to the parking area, but it looks to me like really the variance is for nearly the whole 30-foot setback when it comes to the pond. Can you elaborate on that?
Yes, during the site plan review process, staff is allowed to approve encroachments by stormwater or other pervious encroachments into the 30-foot setback. So the variance is just for the impervious portions of the encroachment, so the building and the driveway and the parking. And the furthest encroachment of the impervious is 15.5 feet.
Thank you for that, Carla. And the applicant, please. The applicant, yes, sir. If you're the applicant. Good morning.
Morning, I'm Terry McCloskey. My address is 321 West Street, Tampa, Florida, 33602. And I'm here representing the applicant for this variance request. And
What's your relationship to the applicant?
I work for SNME, so I'm a consultant for the applicant.
Engineer.
Engineer.
Okay.
I have a couple of slides. It's real quick. It's just to give you a feel for what we're trying to do and what's going on here. Do I do it or do you do it? Just hit the space bar? Arrow buttons, okay. So, right arrow button. So I just wanted to give you an idea that you've got, some of this is a little redundant. This is the area where it's at. It's in Bloomingdale. It's, west of 301. But the picture down at the bottom kind of gives you a feel for that corner lot, which is always difficult. But we just wanted to give you kind of a look at what that lot looks like. It's under half an acre. The building itself is only 1,575 square feet, 1 story. And this is our site plan that's in process now. And you can see that in green there is the EPC wetland line designated as, the top of bank. And then the yellow line is the 30-foot EPC wetback setback line. So you can see where the driveway, I'm gonna show you here. So our impervious encroachment is that brown looking area there, corner of the building, little piece of the sidewalk, and then the driveway with a little bit of parking. And today, the existing driveway pad is actually in the encroachment area. So this used to be, the only thing that could ever really survive here before was like a gas station and stuff. And so we really tried to find a land use that would be compatible and could be small. And this is an appointment only type land use. So the real encroachment impervious is those brown areas that you see. So the 15-foot probably comes along, the furthest encroachment that's there.
Mr. Hearing Officer, sorry to interrupt.
Thank you, sir. Yes.
According to our records, the registered representative is SNME Incorporated. Do you work for that firm, sir?
Yes, sir.
Oh, he did.
He did indicate.
We've overmissed that. Thank you.
I'm sorry. It's probably the mask.
Let's go back to that drawing for a second. I don't want to put.
Sure.
So the existing driveway is encroaching, but I'm not sure where it's pointing to the encroachment in yellow.
Okay, the existing drive and the drive where we're showing is the exact same spot.
Okay, that's what I needed to know.
Yeah.
All right.
We're actually, to meet a lot of the other codes, for parking and drive ways and everything else, we actually were widening that pad, but we're widening away from the encroachment.
So is it fair to say that you're not increasing the amount of encroachment?
Yes, we are, because we're going to put that little radius on it, and then it has to have that 1 parking space. So all that brown there is encroachment. Part of that is the existing driveway, you're right. So I didn't separate what was existing and what was.
That's where my confusion.
Oh, okay, sorry.
Okay. Well, so how much of it is,
I've got that at the end. I've got it broken down.
You do?
Oh, it's me, that's right. So I just wanted to give you a feel, just a look, and I'll get to your question. Looking onto the property, you can kind of see what the wetlands look back, and you can see the guardrails already in the encroachment. And B is looking north, that's from the property over to the Italian restaurant. And then C is the Italian restaurant, and you can see that they're well within the encroachment line, right? So we just wanted to give you kind of a look at what was out there today and what this looked like. And then this table tells you our encroachment for impervious is 13%. If you go to the bottom of that table, it gives you the 30-foot setback, the encroachment, 845.9, which I think Carla mentioned. And then the amount of the building and total encroachment, 873.8. And then, so that comes out to 13% of the total 30-foot setback area.
And just want to make sure that that 13% does not include the pond, which is going to encroach.
Which is impervious. I mean, it's pervious, sorry.
Okay, all right.
I'm losing oxygen.
That's all right. Go ahead.
So this cross-section kind of gives you an idea too of the pond and kind of how this is laid out. It's a very tough site. It's sat there vacant for a long time, and we're trying to minimize any impacts that we can. So that's all I have for you.
All right. Thank you for your testimony.
That's it. Thank you.
Okay. Is there anybody here today in support of this request? Nobody in support. Is there any opposition to the request? None. All right. With that, we'll close variance 20-1373. Tom?
Our next case is item E3, variance application 21-0005. The applicant is Dev and Sarali Ramani. The request is a variance to encroach into the wetland conservation area setback. Staff findings will be presented by Carla Shelton.
Okay. And the applicant, please. Good morning.
Good morning, this is Carla Shelton, Hillsborough County Development Services. The applicant is requesting a variance from the
Ms. Shelton, please stand by.
conservation area. Yes.
Good. Carla's right. I apologize. If you would just kind of have a seat for the moment. Thank you. Go ahead.
Go ahead, Carla. Thank you.
Okay. The applicant's specific request, as shown on the site plan submitted on October 16, 2020, is to allow for construction of a portion of a swimming pool and deck within the 30-foot wetland conservation area setback. Per LDC section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a portion of a pool and deck within the 30-foot wetland conservation area setback. The applicant requests a 15-foot reduction of the setback to allow for a setback of 15 feet. Staff findings: the site has an existing retaining wall located 15 feet inside the 30-foot wetland setback that was permitted and built during the overall subdivision development. That's all from staff.
Okay. Thank you, Carla. And the applicant, please. Good morning again.
Good morning. My name is Sarali Kilramani.
Dev Carol Romani, and our address is 19901 Cypress Bridge Drive in Odessa, Florida, 33556.
Okay. Thank you.
And we're here today to talk to you about using the 15 feet of the 30-foot setback on the property.
Why don't we step up just to get as close as you can to that microphone? Yep.
Is that better?
It is.
Okay. We're here to talk about using 15 feet of the 30-foot setback of our property. Currently, the 15 feet that we're requesting is already grassed. There's a retaining wall, and so we're not encroaching on any, untouched land. We would only be asking to use the grassed area of our lawn. We have a pie-shaped lot home, and so behind our home, we don't have a lot of land space because of the shape of the property. And so we're just asking to use that 15 foot of grassland.
Anything else?
No.
I think the only other thing I would add is we have spoken to a lot of our neighbors, given they've seen the large variance sign on our front lawn. And, we didn't get emails, which would have been smart, but there was no opposition. They were thrilled to support the project.
Okay. Fantastic.
Okay.
Thank you for your testimony.
Okay.
All right. Is there anybody here today in support of this request? Okay, nobody in support. Is there any opposition to the request? Okay. With nothing else, we'll close variance 21-0005.
That concludes section E of the agenda. We'll now move to section F, which is signed variance requests. We have one application. It's item F1. Variance 20-1268. The applicant is Falkenberg Wash LLC. It's a Request is sign variance. Staff report was prepared by Kim King. Findings at today's hearing will be presented by Jim Blink.
Okay, and this question is directed to staff, but could be one of several people. There was no variance criteria in the optics file on this one. And we need to resolve that before we close it out.
I'm sorry, what was the problem, sir?
There was no responses to variance criteria in the optics file.
Okay.
And so I have no official written responses to the variance criteria.
All right.
And so one of the answers could be, hey, you're missing it, but I did look through it pretty thoroughly. So maybe we can have that checked out, but I don't want it is there?
Where?
I mean, it's an option.
Is it in this file case? Is it?
Mr. Hearing Officer, I have it written. I'll be glad to give it to you.
Hold on one second.
I don't know that. I don't.
Okay.
Well, no, but it's here.
Do you have it, Tom?
I'm the applicant. I've got copies.
Okay. This is 1268.
Tom, if I may.
Oh, I have it too long.
Sorry.
Give me 1 second. All right. Sorry.
See here?
12. Oh, I'm sorry. I was on the wrong page. Hold on.
Sorry.
Do you have? He has a copy. All right.
List them in the application.
Okay, if it goes in with the clerk, that's fantastic. I want to make sure the I's are dotted.
Yeah.
Okay. All right.
Okay?
Now we go to staff.
It says, I'm substituting for our project manager, Kim King. She couldn't be here today. So I apologize for being the ugly guy and not the attractive woman. So,
Yeah.
Good morning.
good morning. This is a request by the applicant is requesting a variance for additional square footage for a proposed ground sign for Bubble Down Car Wash located at 10302 Tuscany Ridge Drive. The variance per section 7.03.00.c.2 A and B of the LDC allows one ground sign at 50 square feet per side, 100 square feet total for this parcel with 588 lineal feet of street frontage. They had 600 lineal feet, they would be allowed to have two signs, but because they're short, they're only allowed to have one sign. And the applicant is requesting a variance of 126 square feet of additional signage, 63 square feet per side. This will allow the ground sign to have a total of 226 square feet. And I'm here to answer any questions you have.
I'm good with that, but thank you for the testimony.
Sure.
And the applicant, please. Good morning.
Hey, good morning, Mr. Skrull. I'm Tyler Hudson, 400 North Ashley Drive here on behalf of the applicant. Is the overhead projector working? Okay, wonderful. Sorry, I'm really bad at this. Sorry, again, Tyler Hudson, 400 North Ashley Drive. With me here this morning is Brian Zinneber, who's the founder of Bubble Down Car Wash, which is the business that will be operating from the premises, as well as Brittany Barnett, a certified land use planner with my law firm. So just to be clear, we are dealing with the northwest corner of Tuscany Ridge Road in Falkenberg. This is I-75 here. It's west of I-75, south of the expressway. It's just tucked in a little corner there. And as staff mentioned, the reason we are here seeking what may sound like a significant variance is because, as you know, frontage in Article 12 of the Land Development Code is defined only with respect to public right-of-way. So while Falkenberg Road is a 4-lane arterial managed by FDOT, Tuscany Ridge Drive, when it was platted back in 2008, it wasn't fully developed, as many platted in 2008 developments were. A score of easements were issued over time, but the road was never itself dedicated to the public. It's remained privately maintained, but as you can see, due to the proliferation of commercial development in the vicinity, it does function as generally publicly accessible, and certainly the public will be welcome at the car wash that we are constructing there, but it is not public right of way for purposes of the land development code. So the 126 feet that we are requesting will permit us to build a 226 square foot total sign, 113 feet on either side. If Tuscany Ridge Road were, had been dedicated to the public, we'd be pretty doggone close at that point. We'd be probably about 200 feet. But because it's entirely excluded from being considered towards the aggregate sign area calculation, here we are with only 100 feet. So I'd like to, in terms of the variance criteria, there was some submitted in the application. I have submitted some, just a little bit of a supplementary that walks through each of the 6. And just for purpose of the record, I'm going to go ahead and walk through those now somewhat briefly. So in terms of uniqueness, I do think this is a somewhat unique situation where you have the intersection of a major public road in a commercial area that bisects a private road on which you would have a commercial development. This isn't, Falkenberg and Tyler Hudson Road where there's a house in the very far back. This is a outlet, it's a commercial out parcel, hard corner in the vicinity of a lot of commercial development. And the sign code uses frontage, I think, so that the sign area is proportionate to the amount of parcel that's actually being developed. And here we have a fairly significant project we're putting in, but only half of the street, not frontage, but the street facing area is eligible. And I think that really undercuts the purpose of the land development code. And that's a great segue to the second variance criteria, that the literal application of the code would affect a deprivation. I do think that is the case here, because the sign that we can do by right essentially would be pretty disproportionate. I mean, more than half what we think is appropriate for a location like this. I would add too that Falkenberg, the vehicular right of way is still about probably range between 95 and 120 feet east of our project. There's a pretty heavily wooded strip that is right there. It's a FDOT THEA strip that we've actually negotiated a license agreement with THEA to clear some of the trees, the smaller trees that are there that obstruct our view. But even the frontage we do have on Falkenberg is still fairly far set back. Regarding the third criteria of interference without...
Before you go on,
sure.
Just a quick question on that.
Yeah.
And I don't know whether you misspoke when you said it, but you used the wording, the sign that we would be permitted would be more than half. When you said it, did you mean that, or?
I'm not.
The site is only afforded 50%.
So we're allowed 100-foot sign by right. And what we're requesting is a total 226 square foot sign. So the increase is of 126. So by right, we have less than half of what we would like. That's perhaps what I was trying to say.
Okay.
Yes. Yeah. Sorry. Does that clarify things?
Yep.
Okay. Regarding the third criteria of no interference with others, I mean, respectfully, I don't think that's really an issue here. There certainly are many variances that give rise to externalities, and it's a balance that you have to decide on whether those are appropriate. Here, we just want to have a slightly larger, or have a larger sign than the code would otherwise permit. Regarding the fourth criteria, the promotion of the intent of the land development code and the comp plan is there's a lot of intent in the comp plan, but there's only one word in section, it's 10203 of the land development code about the promotion of orderly development. Signs obviously have a very self-interested nature. We are advertising our business. We want people to come, especially in times like this. But signs obviously have a very clear navigation function. They have a wayfinding function, especially along a busy street, Falkenberg like this, very near the intersection of another busy street, Causeway, and within shouting distance of Interstate 75 in the Crosstown Expressway. So I would submit that this does promote orderly development because it will be much easier for this business to be identified, for people to understand how to get there if our sign is of the size that we are requesting. Fifth, in terms of self-creation, I do not believe that's the case here. We are not asking for forgiveness instead of permission. We very much are asking for permission. Florida courts have ruled that knowledge of adverse conditions does not create a self-created hardship. So we respectfully submit that is not an issue here. And finally, substantial justice. I was a philosophy major, so sometimes substantial justice seems like a lofty goal for a sign variance hearing, but that is what we're looking for. This site, if permitted only to build a sign that the land development code and its strict application permits, that's all we get. I do believe it would substantially interfere with the viability of the business. I think it would substantially deprive the public of easy access to it to figure out what is that. I will say that this is a freestanding car wash. This is not a cement block block that's behind a gas station. And it is not like a Pizza Hut or something that has those iconic looks to it. I think folks will sort of wonder, what exactly is that? And so we do need the signage, adequate signage, to ensure that the public knows what it is, and that we're able to have a chance to succeed in this challenging business environment. So with that, I respectfully submit that we have submitted into the record, either by this oral testimony or in writing, competent substantial evidence of our compliance with the code. And I'm happy to answer any questions.
You have a site plan showing where the sign goes?
Yes. Should have been the application. Up here generally. You're looking here, I believe, at cardinal directions. I'm actually going to ask my client, Brian, to come up here to make sure that I'm not saying something that's incorrect. He has been sworn in. And just, you are looking at cardinal directions here. Up is north.
Thank you. Good morning, sir. Name and address first.
It's Brian Zinneber, Zinober, Bryan, 936 South Howard Avenue, Suite 201, Tampa 33606.
Thank you for that. And you'll need to be on the microphone when you go to have this presentation.
He just marked words.
Right there. This is Falkenberg, Tuscany Ridge, sign.
So it is directly in the corner,
Mm-hmm.
and it meets applicable setbacks.
Yes, it does.
It certainly will as we move through the permitting process. We've, I believe, discussed some of these preliminary laydowns. I don't want to put certainly any words in staff's mouth, but we, I believe, have traded. We're in the permitting process and have traded fairly significant construction drawings with staff. And really, the only issue that's arisen is the size issue.
But this is directly. It will be directly in the corner of the northeast corner of. I'm sorry.
Southeast corner of site, which is at the northwest hard corner.
I want to make sure I'm following you. It looks like it's in the northwest corner of Tuscany Ridge and Falkenberg. According to the north arrow on my map.
When I earlier said you were looking at cardinal directions, I misspoke. You were not. I
was pretty good at rotating, but I'm just saying it's northwest quadrant.
Yes. It's at the northwest hard corner. So you now are looking at cardinal directions. This is Falkenberg right here. This is Tuscany Ridge. And so the sign is going to be at the southeast corner of the site.
Of the site.
But at the site itself is at the northwest corner of the intersection itself.
Right. So the sign is in the northwest quadrant of the intersection.
That's correct.
All right. Anything else?
No, sir.
Thank you for your testimony. Thank you. All right. Is there anybody? Yep. Both of you need to do that. Anybody here today in support of this request? Being none, is there any opposition to the request? No? All right, I want to make sure anything else from the applicant before I close it.
Appreciate your time. No, thank you.
Thank you very much. With that, we'll close variance 20-1268.
That concludes section F of the agenda. Takes us to section G, which are the general variance requests. First case is item G1, variance application 20-0869. The applicant is Genti Tarahi. They're requesting a variance defense requirement. Staff findings will be presented by Tanya Chapella.
Tanya there? Tanya Chapello, can you hear us?
Are you out there?
Ms. Chapello, can you hear us?
We'll go ahead and present staff findings while we clear up the communications problems.
Sure.
The applicants are requesting a height variance for an existing fence on property zoned ASC1. Under the Land Development Code, fences in agricultural districts are subject to the same regulations as fences in residential districts, except under certain circumstances that don't apply to this case. And those requirements are that fences in required front yards are limited to a height of 4 feet. The required front yard in the ASC1 district is 50 feet. The applicant requests a 2 foot height increase to allow a 6 foot height fence for an existing PVC fence in the required front yard on the north side of the property. Also like to point out that under the code, fences and walls greater than 2.5 feet in height shall not obstruct motorist visibility triangles at the intersections of driveways and streets. Subject variance, if approved, will not obviate compliance with visibility requirements, which may dictate changes to the design of the fence.
Thank you for that, Tom. And the applicant. Yes, sir. Good morning.
Good morning. Genty Tahirai, 10409 Ohio Avenue. Well, first of all, I want to say thank you for having me here today. I just wanted to briefly explain our family situation and the nature of this request and why this is important to us. We moved to Florida about 5 years ago with my family, my mother and my father and our 3 children. Wife, I have a sister as well, brother. They all work and live here in Hillsborough County. Myself, I serve my community of Hillsborough County as an emergency medicine doctor at Brandon Hospital, and which includes the area of Tornado Sosa. And I'm on daily basis on the front lines fighting the COVID-19 pandemic. What occurred to us is it's a bittersweet, sweet because we moved here and we love the property, beautiful trees. My father, who was a beekeeper, he found this perfect shade where he could place his bees. We planted fruit trees together with our family. And my father was the primary person who would serve the property, and he would go check on it. We don't have a residential property on property there. It's just vacant land. He would tend to the bees. He would tend to the trees, made a lot of improvements to the land. Unfortunately, he died last year of pancreatic cancer. And me, as a busy emergency medicine physician, out of a sudden, not only I had to deal with the tragedy of losing a father, but now I had to tend to this vacant land property that he was tending to. We checked several times on the property, and brought my kids there as well, my 3 daughters. And to our disappointment, it was the north side of the property was a hazardous state for our family. This is a family recreational venue where we take our children to play hide and seek around the trees, where they ride their bikes, and we collect the fruit trees that my dad planted for us. It's a family legacy property. When your child comes to you and says, "Daddy, I found this needle. Daddy, I found this syringe," and they bring broken beer bottles to your attention, that does make an impact on you as a parent. And I'm sure, and our neighbors and our community identifies with that. As a father of 3, I felt that the property needed some enhancement, and the round down fence that was a pre-existing round down fence that was on the northern section of the property was 4 feet was more like 4 feet that had become 2 feet because it was so round down, and there were some wires. People were just easily crossing our border, the northern border.
Was it just a barb fence?
Just a little barbed fence, like chicken wire, some areas. It was all like tilted, and you could just walk over it. There was no fence, pretty much. And it was very obvious due to what we were finding on the property that people were just crossing that fence and conducting perhaps illicit activities on our property, including drugs and and alcohol on our property and breaking bottles and bringing trash there. We looked at the property, we looked at our neighbors, we talked to some neighbors, and we wanted to enhance the property in good faith. Therefore, we looked at our northern neighbor, the Spanish Main, had a beautiful PVC fence, a 6-foot wide PVC fence. And we said, okay, well, let's enhance the neighborhood and match that existing fence that our neighbor on the north end has. We built a sturdy 6-foot wide PVC fence to match the neighborhood, to enhance the neighborhood. And we built it in good faith to keep also the illicit activities away from our property and protect our children.
Now, when you say the north end, you're referring to across the street.
Across the street from Ohio Avenue. I hope I don't have the compass here. You know, that's the Spanish Main. It's right across. It's right across from the Ohio Avenue.
Yeah.
The Spanish Main property. I believe that is the north end, right?
It's across the street to the north.
Right.
Yeah.
Right. So we built the fence within our property lines. There's no encroachments here. There's no, the fence is just, it's where the pre-existing fence was. We had actually, we redid the survey as well to make sure that we were respectful to the boundaries of the property, and the fence, the new fence was going to be respectful to our neighbors and only enhance our.
Who was it that constructed the fence?
We hired a local company. It's like pretty much we did it ourselves with some help, pretty much. A local Tornado Sosa company. I forgot their name right now.
Is it a fence company, or you just hired the labor?
Just hired the labor. Pretty much we did it ourselves. It was like a do it yourself on the weekend. When you're not working in the emergency room kind of project, you know? So the kids loved it, the wife loved it. we felt like this was the right thing to do, and we had plenty of support from our neighbors. Scott from the west side is like, "Oh wow, this looks beautiful." It was an expensive fence too. We spent about $12,000 on it. Everybody, we got praises from everybody. Wow, the property looks a lot better. It's more beautiful and it's a lot safer. One of our neighbors had a break-in just a few weekends prior to that. So he's like, "Oh my God, well, this looks pretty good." People were jumping our fence and going to his property. So now they can't do that. So in a nutshell, we build it in good faith. We build it with our neighbors in mind. We build it in a respectful manner. I'm in the front lines fighting the COVID-19 pandemic. I don't know the small prints on the codes. These codes are large, as we all know. The small prints on the codes, I did not know that there was like a 6 foot versus 4 feet. I mean, I can tell you a lot about medicine. I can tell you a lot about pneumonia and how to help you with that. But when it comes to the fine print on the code, I'm useless, So I am coming before you today in good faith, and I hope this request will be taken in consideration. I want to thank you in advance for looking at this. It's my family here. It's Christina, my wife Marcela, and my mother-in-law Tefta. She just planted some avocados there. We want to see that property grow and flourish and have the children play, and also protect the legacy that my father did leave us behind. I believe this fence will help our pursuit of happiness in this beautiful country of the United States that we love and we serve on a daily basis. And I hope that this request will be taken in consideration.
Okay, one moment.
Yes, sir.
Mr. Hisney, can you confirm that this fence would not have required a building permit in Hillsborough County?
Yeah, correct. Building permits are not required for fences unless they have masonry footers for the posts.
But compliance is required, but building permits are not. Compliance.
Yes, you must comply with the requirements of the LDC, but you do not have to get a building permit, again, unless there's like cement foundations for the posts.
One of the very few things that doesn't require a building permit.
Thank God.
Anything else, sir?
No, unless you have any questions for me, I'd love to explain to you. I know you have maybe more important cases, so I don't want, but if you have any questions, I'd love to answer.
I think I understand. Thank you, sir.
Thank you so much, everyone. God bless you all.
All right, make sure to sign in over here, please. All right, is there anybody here today in support of this request? Anybody that needs to speak in support of this request? Okay, seeing none, is there any opposition to the request? No. Okay, with that, we'll close variance 20-0869.
All right, the next case is item G2, variance application 20-1095. The applicant is Frank Quintana. The request is a variance to lot development standards. A staff report was presented by Kevin DeFrank. However, I will be making the presentation at today's hearing. The applicant is requesting 2 setback variances for a rear porch addition that is under construction on property zoned RSC 6. Under the Land Development Code, a minimum rear yard setback in the RSC district is 25 feet. The applicant requests an 11.6 foot reduction to the setback to allow a setback of 13.4 feet from the rear property line. Also, under the Land Development Code, a minimum side yard setback of 7.5 feet is required in the RSC district. The applicant requests a 3.7 foot reduction to the side yard setback to allow a setback of 3.8 feet from the east property line. I want to point out that the subject porch addition does not conform to the design requirements for a covered patio as defined by the LDC, and therefore is subject to principal building setbacks. Construction began on the addition without building permits, and the property owners was issued a notice of violation earlier this year. And finally, according to the survey submitted by the applicant, the existing pool deck on the property encroaches into a platted utility easement at the rear of the lot. Staff has advised the applicant the encroachment is not permitted and to contact real estate staff regarding the vacating process.
Tom, well, you wouldn't happen to know if that encroachment, the pool deck, was it permitted or no?
I don't know, sir. It was really outside the purview of this variance request.
Okay. Thank you for that. And the applicant, please. This is variance 20-1095. Good morning.
Good morning, Officer Scarola. Good morning, Mr. Hisnick. Good morning, Ms. Mason. This is Daniel Perdomo. I'm here with Mr. Frank Carpio. Property address is 2505 12 Oaks Boulevard, Tampa, Florida, 33637.
Okay, what is your relationship to this request? Are you the contractor?
I'm a contractor, yes.
Are you the contractor who built
I'm the
it?
contractor that's filing for the after-the-fact building permit.
Okay, listen carefully. Are you the contractor that built the structure?
I'm not.
Okay, so you were brought in at some point?
I was brought in at some point by Mr. Carpio, who's here with me.
Okay, and at what point was that? What point were you brought in?
After the fact, after he had built it and after he was issued the violation notice.
Okay, give me a month or some piece of time that I can relate this to.
May of this year.
May of this year. And when was the violation issued?
April.
Okay. And so you are you're acting as representative. Are you intending to be contractor or just acting as representative?
Both.
Okay. You're a licensed contractor?
Yes.
Building contractor, general contractor?
General contractor.
Okay, go ahead, sir.
I want to just show you an image of the survey. You may see the addition there on the back side of the property.
Mm-hmm.
And so the addition is an addition to the existing property. It's an unconditioned space, but it is roofed, and the request is for the side encroachment and the rear encroachment.
So tell me about it a little bit more. What stage of construction is it in?
It's the shell is pretty much built, block CMU, and roof with trusses. That's at the point where the violation came in. None of the stucco finish or paint had been installed, but I would say it's about 95% complete.
So is there a connection between the principal structure, and this addition to the principal structure? So is a door opening? Okay, if you would kindly turn the phone down.
Yes, this is it's a roofed-in structure, but it's completely open. It's unconditioned, and there's a sliding glass door where you would enter to the main property.
Okay.
Connection right in that space. An existing sliding glass door.
So you want to give me some understanding of how this is not the result of an illegal act?
I'm sorry, could you repeat that again?
You want to give me some information as to how this is not the result of an illegal act? That's one of the criteria for issuance of a variance.
Well, we don't believe this is it's an illegal act. Obviously, the nature of this request is it's as a result, almost as a self-imposed hardship, which part of it is Mr. Carpio here not being fully knowledgeable of the code and understanding. So in a nutshell, he is in fact asking here for forgiveness. He did submit obviously building plans, which are being reviewed by the building department right now, which are associated with this application. And he noticed all of his neighbors to make sure he, just kind of did what was required for him to do at this point moving forward.
So just so you can keep this in mind, they give me the criteria that you see here that you responded to, and I'll by all means review your responses as I do this, but that doesn't negate the fact that it can't be the result of a self-imposed hardship or a illegal act. So you're welcome to support that any way you can before I start reading what you wrote.
Other than what we have listed on the application, I could just let Mr. Carpio answer any questions you may have directly for him.
Well, so that's my question, and either one of you is welcome to supply information.
Give me just 1 second.
Yeah, sure.
Well, the only thing we have listed on the variance criteria response, point number 1 is the main hardship is, the completion of the non-permitted rear porch, which encroaches on the rear and side setback, which is now more of a financial hardship for the owner. We did list and mention earlier the unfamiliarity with the requirements of the LDC, and we believe the setbacks encroachments as listed on number 3 are somewhat minimal. The real hardship here would be having to incur any cost to demolish this or substantially lose on everything he spent here. He does have a family he's supporting with 3 daughters, and he recently had additional financial hardship with loss of hours in his job during the COVID-19 pandemic. So he would like to asked for this petition to be taken in consideration.
Okay, and listen, you can only supply what you can supply, but this question needs to be answered in the affirmative sense for any grant of a variance. This is criteria response number 5. Do you have the responses with you?
Yes, sir.
Explain how the situation sought to be relieved by the variance does not result from an illegal act or result from the actions of the applicant resulting in a self-imposed hardship.
Well, yeah, the response on the variance criteria, item number 5 was that, the situation requested to relieve from is a self-imposed hardship, and that's the reality. Is he's asking for forgiveness here because of his lack of knowledge to the code. Very, sorry to bring this up, but it's very similar to the gentleman that was here before with respect to his fence, the doctor.
Yeah,
Mr.
so
Carpio,
that's not a good way to go. What's a better way is describe who built this? Who built the structure?
He did. Him and his father did.
Okay. And they just who built the pool deck that's out there?
That was existing. He purchased the house
with the pool deck.
With the pool deck, yeah.
Okay.
Now he's aware, obviously, now that there isn't the slab. It is actually part of the pool's deck is in the encroachment, and he's actually preparing to repair that and do any necessary modifications, so he's in compliance with that as well.
Okay. All right. So anything else that either of you wants to add, you can now before I go on.
Yeah,
Good morning.
My name is Frank Carpio, and I'm knowledge of I did the construction without permit on 7505 12 Fox Boulevard.
Yes, sir.
Yeah, it was my mistake to build that up, but didn't have the knowledge that I didn't know all the codes. So I started building it with my father. When we did ourselves everything, we were on the perimeter of the fence. Well, we thought it will be, it's in our property, so we thought everything was fine. It was a existing small porch. We just increased it a little bit bigger. That's where we violate the setback.
Okay.
So thank you very much.
All right, thank you, sir. Anything else?
That's it, sir.
All right, and if you would step over here and sign in. Anybody here today in support of this request? Seeing none. I think we had one sign up for opposition.
Yes.
Go ahead, David.
Hi, my name is David Gagliardo, 7509 12 Oaks Boulevard. Just to touch on a couple of basic details that were already talked about. Number one, the construction began without submitting a building plan and getting approval for it. Second, construction began without applying for all the necessary permits. Number three, construction began without applying for a variance for the setback encroachments. Prior to construction, the homeowner had built a 7-foot-high PVC fence around his backyard, which consisted of a standard 6-foot-high PVC fence placed over cement blocks. I didn't know that. I had assumed that licensed contractors had built this home addition, but now he's saying that he and his father built this. Now, is the homeowner in the construction industry, or is the father in the construction industry? I think that's an answer that needs to be made. But anyway, I would ask the board that when you deliberate on this to please keep in mind that if you approve a variance for this illegal construction, that's what it is, you'll be setting a precedence of unharmonious and out of control construction projects in 12 Oaks. and that will irreversibly damage the desirability of my neighborhood, thus leading to declining property values. Now, going back to some of his responses on the variance criteria response sheet, number 5, I won't reread the question, but really the act of building on the setbacks is a direct result from the actions of the applicant. Question 2, his response doesn't even really answer the question. And number 3, on the criteria response sheet, it would deny my rights to equal treatment of the land building code, because if I can't, just start building willy-nilly on my property without getting the variances and permits, well, then neither should he. And number 4, again, the homeowner's response doesn't really answer the question. And number 6, with regard to his response, he hasn't presented any evidence to back up those claims. And that's basically all I have.
Can I ask you where where's your residence in relationship to the request?
I am 2 doors down from the subject property.
Action. In which direction? 2 doors down?
Oh, I'm sorry. Well, I'm at 7509. So if you're looking at his house, I would be 2 houses to the left.
Okay. All right, sir. Thank you very much for your testimony.
Thank you.
All right, anybody else that needs to speak in opposition to the request? Okay, seeing none. Tom, anything to add to it?
Yes, sir. The survey that was submitted by the applicant did not indicate the height of a fence, or I think even the presence of a fence. I want to advise the applicant that if your fence is above a height of 6 feet in your rear yard, as was indicated by the gentleman, then that height is not permitted, and you're going to either have to lower the height of the fence to 6 feet or seek a separate variance to address that 6 foot height. Or I'm sorry, if you lower it to 6, you're fine. If you want to keep it at 7, you would have to seek a separate variance to keep it at the 7 foot height. Okay.
Thank you, Tom. Hey, gentlemen, have an opportunity for rebuttal if you need to say anything. Here, come on up. I'd like you to. Come on up. What does the homeowner do for a living?
He is a maintenance and construction technician for a large property owner here in Florida. He owns a portfolio of hotels and apartment complexes, and that's what he does.
Okay. Does he have any sort of contractor's licensing or?
No, sir. He has knowledge, obviously, from have worked in the industry. Okay. So does his father. They work for the same company.
All right. Anything else you need to add now before I close it?
I just want to apologize to the neighbor if it is.
Say your name.
Frank Carpio. I just want to apologize to him if anything that I build that it interferes him and he's not agree with it. Just apologize to him, and I didn't do it with bad things. So I just tried to do myself what I thought it was right. I know now I knew it's not right and it's not by code, but it's already built. So that's why I was asking if they at least they let me keep it. I'm not gonna, if I had to lower the fence, any correction that I had to do, I'm willing to do it. I'm willing to do any corrections, just at least to let me keep it for now, because everything is already built and all the expenses are already there. It will be more expensive to demo everything, and everything will be lost.
Okay, sir. Thank you very much for your testimony.
Thank you.
All right. With that, we'll close variance 20-1095.
All right, our next case is item G3, variance application 20-1113. The applicant is Robert Best. The request is for several variances to accommodate a proposed 3-lot subdivision. Staff findings will be presented by Laura Marley.
Good morning, Laura Marley, Development Services. The applicant is requesting variances to accommodate a proposed 3-lot subdivision. A minimum lot size of 1 acre is required for a septic system within water resource protection areas. The applicant wishes to subdivide an existing 2.91 acre parcel into 3 lots. The applicant requests the following lot variance sizes. Number 1, lot 1, a reduction of 0.10 acres to the minimum required lot size to allow for 0.90 acres of upland, not including the easement area. Lot 2, a reduction of 0.38 of an acre to the minimum required lot size to allow for a lot size of 0.02 of an acre, not including the easement area. Lot 3, a reduction of 0.18 acres to the minimum required lot size to allow a lot size of 0.82 acres, not including the wetland area. The new development in urban service areas required to connect to public water and wastewater services. The applicant requests a variance to allow the creation of 3 lots to be served by private wells and septic tanks in the urban service area. Public utility staff has confirmed that connection to the public wastewater service is not cost feasible for the proposed 3-lot subdivision. And a minimum side yard setback of 7.5 feet is required. The applicant requests a 3.3 reduction to the required side yard setback to allow an existing 4.2 side setback for a carport. And then the survey has multiple notes that multiple structures on this site has been removed. But particularly note 8 on the survey, the principal residence and accessory structures are currently within the building setbacks. The applicant is proposing to remove them and will replace the principal and accessory structures that meet setback requirements. And then the applicant states that they reside on lot 2, in which case you'll see 2 mobile homes. With them residing on lot 2, they would be allowed to have an accessory dwelling unit. Thank you.
I'm wondering if, before we hear from the applicant, if staff can help sort of relatively get me to understand something here. There's 2 different issues affecting area. One is the easement area, and one is the wetland area. And in my own mind, I'm trying to say, well, so you would have needed 3 acres of upland in the wellhead resource protection. How many total acres of upland do we have? Do we know that answer?
Or can you?
Let me look at the survey. Okay. The survey should tell me okay, so lot 3 is 1.04 acres. And 0.82 acres are upland of that.
Okay, give me 1 second with that.
And you'll see on the survey proposed lot 3 at the rear, they have the wetland line depicted.
Lot 3 is 0.82 acres of upland. Lot 1, we know, is 0.9 acres of upland. So that's roughly 1.8 acres of upland. What about lot 2?
Lot 2, there's no wetlands on lot 1 or 2, just wetlands on lot 3. The area that I was speaking to that was left out of lot 1 and lot 2 is easement area.
the words 0.9 acre of upland, regardless of whether there's any wetland, leads me to believe that, okay, we have 0.9 acres of upland on lot 1, right?
Correct. In total,
size of 0.9 acres.
1.0, yeah, 1.08 total. It's less, it's less the easement area. So it's 0.90 acres. And then if you, it's 1.08 acres. If you remove the easement, because lots aren't supposed to include the easements, it's 0.90 acres.
Ms. Marley, I know I'm helping to confuse the situation, but you're still giving me what I'm looking for. But
okay,
right now we're not talking about easements in my mind. We're only talking about lot area. And so I was wrong when I said it. It's 1.05 is the total lot size of lot 1. There's no wetlands.
Correct.
And then lot 2 is 0.83. Is that fair enough to say?
Correct.
Okay, and lot 3 is 0.82.
Of upland, correct.
Okay. So we're sitting roughly at about 2.65 of total uplands. And 3 would have been required to create 3 lots of 1 acre size. Is that fair to say?
Correct.
Just through our technical crew here at the hearing, but I got to correct that 2.65 is the total amount of uplands. Really, if you were just looking at the uplands, there's a variance needed of almost 0.35 acres. And I know you have to look at it on an individual basis, but on a whole, it would have been a 0.35. The easements that are shown, is it all the same easement, or are there 2 separate easements?
There is one easement. It goes, it's on the, I'm sorry. There's one easement for ingress, egress, and there's another easement, I believe, for electric on the right side. So on the east, there's an electric easement, and on the west, there's ingress, egress easements.
You're not subtracting out the electric easement, only the ingress, egress, is that right?
Correct.
Yeah. So the same easement that's referred to in lot 1 is the easement that's also referred to in lot 2. So we really have an overlap of that land. Is that right?
Well, on lot 1, that's the easement on lot 1, and lot 2 is, they're both covering it, but it's not double because there's one easement for each proposed lot. But yes, it is the same easement.
Any way for you to point that out? Because I don't see anything that I can tell it on from these graphics. Eventually, I'll get to the applicant. I want you to know, but I kind of wanted to understand this from your perspective.
The ingress, egress easement?
Yeah.
Okay. Let me see. Can you see my screen?
I can.
Okay. So this is the easement here. This is a 30-foot easement, lot 4, proposed lot 1. This is proposed lot 2. This is the same easement, and then it comes in to 20 foot, and then it comes back out to a 65 foot. So this is one easement, but this is just one easement for lot 1, and the same easement, but one easement lot 2. And then this one's the electric easement on the east side.
Okay. Now that's curious that when you're in lot 2, the easement goes out to 65 feet. And it appears as though somebody's trying to pick up the geometric configuration of a drive or something like that. That's unnecessary easement, right?
Correct.
So there is some area of access easement that is that is being subtracted that really, from a code standpoint, wasn't really needed.
Correct.
Okay. All right. Thank you, Ms. Marley.
You're welcome.
And the applicant, please. Good morning.
Good morning. My name is Mary Best. My address is 5003 Timberland Street. I'm here on behalf of my father-in-law, Robert Best. What started this whole process was we currently have a block home, which my father-in-law owns, and there's 3 mobile homes. One my husband and I own, one my brother and sister-in-law own, which is lot 3, and then there's the accessible on lot 2, the second mobile home. What started the process is we wanted to remove, my husband and I wanted to remove our mobile home on lot 2, put a new mobile home in to put my parents in there to be able to take care of them. In speaking with Mr. Hisney, he said we needed to subdivide the property, which is what started the process of all of this. So basically what we're looking for, I guess, is to subdivide into 3 lots with upgrades.
With I'm sorry, say again?
With upgrades.
Yeah.
To be able to change the mobile homes and upgrade them.
Yeah. All right. Give me a little history about the property. How did these units get there? I need some historical background.
Okay. My father-in-law has owned the property since 1962. Most of the mobile homes have been in there since the 1970s, which I think back then probably Northwest Hillsborough County probably didn't have a whole lot of zoning. So what we're trying to do is at this point, because they're getting older, we're trying to upgrade and invest in the property.
So because there may not have been zoning, according to what you just said, in the 70s when it happened, or there may have been, you the first thing you did was you went and applied for a legal nonconforming status on the property?
Yeah, we went down to zoning. At one point, my father-in-law went to the courthouse and applied for the property to be a mobile home park. Okay, but that never got transferred into zoning, so we had to forget about that. We tried to put in an application to become a mobile home park. That was not accepted, and we went on to the subdivision portion of it. Because as far as the mobile home, it would not allow us any upgrades.
Okay, hold on for 1 minute. I thought that I read it, and it's been a little while since I read it, but that you had applied for legal nonconforming status. Bear with me for a second. Tom, does that ring a bell?
Yes, there were either discussions or an actual application. I think Laura could.
There was an application.
That.
We applied.
There was an application. Yeah. Very early in our review, it became apparent in discussions with the applicant that the reason they were applying for it is that they wanted to replace some of the mobile homes on the property. At that point, we advised them that there was no reason to pursue the non-conforming use because even if it were approved, and we didn't know whether that would be the case or not, but even if it were approved, it would not allow replacement of the mobile homes because the code says you want to return to a conforming status. So 2 of the mobile homes eventually have to go away. And the last one, if it met the accessory dwelling requirements, could have remained on the property. But since that's not what they wanted, where they wanted to go with this property, I mean, it was driven entirely by their desire to, as she says, upgrade, replace some of the units, then the NCU was not feasible. We didn't pursue the review. Because again, it would not get them where they wanted to go. The subdivision of the property is what's required to get them to permit replacement then of some of the mobile homes.
Great, thank you for that. And then one other clarification for me is I lost count somewhere. How many structures, residences are on the total property right now?
4.
4. And how many will be there when you're completed with this?
4.
But there's 3 lots.
Yes.
That are proposed. Which lot gets 2?
Lot 2. And currently there's 2 mobile homes sitting there right now on lot 2. Because if once you subdivide, you're allowed an accessory dwelling.
Well, so you would have to apply for an accessory dwelling.
Right. Well, as noted in finding 3, the applicant has confirmed that lot 2 is the lot that they reside on as the property owner and will continue to reside on. They are then permitted to have an accessory dwelling, provided that accessory dwelling is not more than 900 square feet in size. And they understand this, and they stated that one of the mobile homes or both are being removed and will be replaced in conformance with setback requirements, and they are aware of the size restriction on the accessory dwelling.
Absolutely. Aware of all of that.
Anything else, ma'am? Thank you for your testimony.
Thank you.
Okay. All right, anybody here today in support of this request?
We have Thomas Young online. Thomas, can you hear us? Thomas, can you hear us? We couldn't hear you there for a second. Thomas, please check your microphone. We're not getting any audio. We are not hearing you. If you hit the downward arrow next to the mute button and click use internal systems. Thomas, we're getting feedback from your microphone there. We're not picking you up at all. It looks like you're having some audio issues. You may want to hit use system settings or change your microphone settings. I'm sorry, Thomas, nothing's coming through.
Maybe just work with them. Want to give them every opportunity.
Thomas, if you could back out of the meeting and rejoin real quick, that usually will fix it. Thomas, can you hear us?
I can hear you.
I can hear you. Yep.
Fantastic.
We should be good, Thomas. Go ahead.
Good morning, sir.
Good morning, Thomas Young. And I was the surveyor that worked on this project. I don't have too much to add, just that besides the replacement of the structures, there's not any real development going on, so there wouldn't be any additional impacts to traffic, wetlands, that sort of thing. I didn't know if you had any questions for me.
Mr. Young, other than the variances that are being requested today, are you aware of any other complications of getting a plat approved?
No, just those 3 variances.
Okay, thank you for your testimony. Anybody else in support? Is there any opposition to this request? Good morning, sir.
Good morning. My name's William Best. This is my father right here. We're basically just trying to make this a family property.
Okay, I need to correct something for the record here. I asked for opposition, and I'm assuming if your name is Best, you probably aren't opposing the project. Am I right? It could be.
I got up before you got
right,
a little late. I'm sorry.
So let me ask you, you want to support the project?
Yes, please.
Okay, go ahead, sir.
My name's William Best. I live at 5003 Timberland Street. It's it's a family property. My mother and father established the property. My brothers lived on it for many, many, many years. I've lived there since I was a child. Now we're trying to get my wife's parents on the property. It's just, it's something that we're trying to make everything legal. Back in the day, I understand, these old guys, they didn't do a lot of things legal, but nowadays I'm in the construction trade. I've been a plumber all my life. I know how important things, pulling permits. You've got to pull permits. Things has got to be done legal. If you ever was to try to get rid of your property, then problems occur. We don't want those problems in the future. And I do not foresee selling that property at all. It'll go to our children. But that's about all I have to say.
Thank you for your testimony, sir.
Thank you.
All right. Anybody else in support before I close support? Okay. All right. And making sure there's nobody in opposition today. All right. And let's see. I think with that, is there anything from staff that before I close it out?
Yes, this is
Laura, do you have anything to
Development
add?
Services. I just want to amend my statement. Public utility staff has confirmed that connection to public water and wastewater service is not cost feasible for the proposed 3-lot subdivision.
Thank you for that, Ms. Marley. And does the applicant need to add anything else before I close it? All right. With that, we'll close variance 20-1113.
Next item is G4, Variance Application 20-1196. The applicant is Kali Anamathi Rathanasamy. The request is a variance to accessory dwelling requirement. Staff report was prepared by Kevin DeFrank. I will present the staff findings today. The applicant is requesting a setback variance for a proposed accessory dwelling on property zoned AS1. The Land Development Code requires that accessory dwellings meet principal building setbacks. The required rear yard setback in the AS1 district is 50 feet. The applicant requests a 35-foot reduction to the required rear yard setback to allow a setback of 15 feet from the north property line. Maximum size that is permitted for an accessory dwelling is 900 square feet of living space. And I would ask that the applicant's representative confirm that the proposed accessory dwelling will conform to that requirement.
Good morning.
Good morning. I have not been sworn in.
Okay. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do. All right, I'll start with the easy stuff. My name is Patricia Ortiz. My address is 2810 North Central Avenue. In this particular instance, we feel that the backyard is the most appropriate location for an accessory dwelling, and that's because it will preserve the oversized front setback of the area. It'll allow maximum separation from the on-site wetland and the southeast corner of the property and the floodplain in the northwest corner. It will also have the most minimal impacts on surrounding properties. The property to the south is developed with a church, a fence, mature trees, buffer area, and parking for the church will exist on the adjacent property between the accessory dwelling and the church building. Also,
I thought somewhere in her, I lost you. I thought somewhere in there that you said south, but that's to the north.
It is the north. I'm sorry.
Okay.
Okay. Do you? Okay, here we go.
I got it.
Okay, so the property.
Go ahead.
Oh, sorry about that. The property abutting to the north is actually a church. There is a fence separating the property line. There's mature trees, thank you so much, and the parking area of the church between the location of the accessory dwelling and the church building. And that might be better shown in the aerial photo that I have here. As you can see, this is the church.
I can't actually rotate it 90 degrees to your left, to the left.
Okay, perfect. So we have the church right here.
Still got to get on the mic, though.
Okay, here we go. We have the church building right here. We have the mature trees I was speaking of.
Yeah.
And the church parking lot. So if we place the accessory dwelling as located approximately where this pink spot is, the accessory dwelling will be most distant from, adjacent buildings, and I feel most appropriately located considering the characteristic of the neighborhood.
Okay. Anything else?
That's it for now.
Thank you
If
for
you have
this.
questions, I'm happy to answer them. Thank you.
All right, anybody today in support of this request? No. Any opposition to the request? All right, and Tom, anything else before I close it?
No, sir.
All right, anything else from the applicant? I got a no from the applicant, so we'll close variance 20-1196.
Our next case is item G5, variance application 20-1200. The applicant is Jose Luis Sanchez Pina. The request is a variance to the distance separation requirement for a proposed community residential home. Staff findings will be presented by Chris Grangillard.
Good morning. I'm Chris Grangillard, planner with the Development Services. I'm here to present variance 20-1200. The applicant is requesting separation variances to allow a proposed community residential home type A with 6 placed residents or less to be located at 3410 West Grove Street within 1,000 feet of 2 existing type A community residential homes. Here are the variances per LDC section 6.11.28. A community residential home type A shall not be located within a radius of 1,000 feet of another such existing home with 6 or fewer residents, as measured from property line to property line. According to state licensing data submitted by the applicant, there are 2 existing community residential homes within the 1,000 feet radius of the proposed facility. One at 5805 North Lincoln Avenue, the other at 3134 West Burke Street. The applicant requests a 400-foot reduction to the required separation from the existing home at 5805 North Lincoln Avenue to allow a 600-foot separation. Also, he requests a 290-foot reduction to the required separation from the existing home at 3134 West Burke Street to allow a 710-foot separation. Here are some findings. There's a shed in the back yard that does not meet accessory structure or setback requirements, and the applicant has declined to include the accessory structure setback variance in this application. That concludes my staff report for variance 20-1200. I'll be glad to answer any questions you may have.
I don't have any, but thank you very much for that. And the applicant, please. Good morning.
Hi, good morning. My name is Martha, and I'm here to assist Mr. Jose in presenting the case.
Okay, so you aren't very close to the mic. Why don't you get a little closer, say your name one more time so I can hear it.
Can I remove my mask? Or?
Whatever you need is fine, but just stay close to the mic.
Sure. My name is Martha Medina, and I'm here to assist Mr. Jose in presenting his case about the variance application. Oh, I'm sorry. We have presented, we have a PowerPoint to present our case, okay? Before we proceed, I have the answer to the shed. It's not included on this variance, but if requested, we can remove it in order to meet the requirements by the county, okay? No, I don't see a block. This is a blind. I don't see the drive there. Okay.
Sorry, that's okay. Or did it take?
It's called Kingston.
Yeah, see, I don't see it. Sometimes it doesn't come up.
Oh my God.
But you emailed it to me, didn't you?
Yes,
I'll check.
And do me the favor, of just wearing your mask while you're near
Sure. It's
the
fine.
staff. That's all right.
I'm sorry, we can see it on the computer.
It's not coming up.
The name is Kings.
This is in here?
Mhm.
There's no the court getting it here. Give me 1 second. Let me see if we could bring it up.
I put it back in.
Okay, while that PowerPoint's coming up.
Okay, now let me start.
Wait, 1 second.
Okay.
Little technical issue, but just want to confirm here.
Oh,
So you are representing this homeowner, but you aren't a designated representative.
No.
So why don't you talk to him and get him to confirm on the record that you're the designated representative?
Good morning. My name is Jose Sanchez, and I give her permission to speak.
Say her name.
Marta Medina.
Okay, thank you.
Thank you.
Okay. All right. So if you can see it, we're requesting a variance for distance separation for the property 3410 West Grove Street. And we're here for Jose Sanchez. So basically, the nature of our request is a distance separation. The basis of our petitions, our proposed CRH will not overpopulate the neighborhood. The proposed CRH will not cause any damage or inconvenience to the existing surrounding property or neighbors. We're proposing a request of approval for a variance application from the following address. There are two additional CRH within 1,000 feet, 5805 North Lincoln Street. We're requesting a reduce from 1,000 feet to 600 feet, 3134 West Burka Street, from 1,000 feet to 710 feet. These facilities are not assisted living facilities. They're also type A, but they're not assisted living facilities. They serve a different kind of population. They don't serve older adults. They serve adults with disabilities. So these facilities offering temporary sheltering to these adults. We offer a home for the elderly. So basically, we have a map. The star is the proposed community residential home. The purpose of this map, I understand that the distance are measured in a linear distance. So if we're going to take in consideration the driving and walking distance, there are more than 1,000 feet of distance in between the properties. So basically, there are 1,056 feet from 3134 West Burke Street and 1,052 from 5805 North Lincoln Avenue. Again, the home will not lose the home-like environment, okay? We will not convert it into any facility or anything institutional. It will look exactly the way it looks. We took in consideration a couple of reasons. We understand that the petitions are approved in a case-by-case petition, providing a method or a way to reduce the distance. Our CRH will provide excellent service to the older adults in a home-like environment, like I mentioned before. So it will look exactly the way it looks right now. We thought about a couple things that the neighbor might be concerned about. So basically, electrical wise, our community will also only provide services to 6 residents, which do not cause any harm to the community electrical service. Electricity does go from time to time, but our CRH is not the cause of the problem. These houses are old and do not have underground electricity, reinforcing that in fact, we will install a generator which will provide electrical power for 5 consecutive days in case we lose the service. Water-wise, as owners, we have never encountered any water or sewer problems. Constructions in all areas of the Tampa Bay or the community can cause waste to go to rivers and lakes, which, we will not cause any of those problems. We understand that might be a concern for neighbors if we have to call the first responders. When first responders are called to assist a resident, they come with sirens off, only lights on. And there always room for parks to drive by. We understand that the property is in a dead end. However, we ask the neighbors and the board to take in consideration that would be the same situation if any other neighbor required to call the first responders. Parking and transportation, the proposed CRH has a private driveway for staff and visitors. Remember, we serve older adults. Most likely, they don't have a car. So it will only be 1 car for the staff member who is serving those residents there. It will not cause any inconvenience to neighbors, nor restraint of any current neighbor parking privileges. Property value. Our CRH will not decrease the property value of the neighbors. On the contrary, we will increase your home property value because we will keep this facility well kept and nice because we want to attract clients. If the pandemic becomes an issue for neighbors or the board, okay, it is not proven that CRH can attract people who are sick. On the contrary, our staff is tested on a bi-weekly basis. If there's any issue or concern, we will have it right there. This is the look of the property, and it will remain the same. And I reinforce on the shed that was mentioned by the zoning officer. If there's any issue with the shed and we need to remove it or do something, the property owners are willing to work on that. So selling this property to buy one located more than 1,000 radius away from the existing community residential home will create an undue hardship. Keeping in mind that those existing, we couldn't locate it on the Acapulco because they're a different kind of service. So initially, that's why they bought the property. Our hope is to continue to provide services for the elderly in a safe residential community home. Lastly, to proceed, request does not impose any hardship for the neighbors, nor will it serve to create situations where any neighbor quality of life, property value, or peaceful coexistence will be negatively affected. Quite the contrary, the proposed request that will allow us to become better citizens and serve older adults in the community without forcing them to move to nursing homes. Our goal is to preserve public health, safety, comfort, and welfare. And if you have any questions, feel free to let us know.
So the one question I have is, how did you get to this point now where you own this house, you're proposing to have this use with 2 structures that are closer than the code provides for?
Okay, the property owner currently owns another assisted living facility within the city of Tampa limits, okay?
With the existing property owner? This property owner sitting with you?
No, this is a county limit. So the question was why they want to do that in that property?
No, the question was, at what point, how did you get to the point that you own the property where you want to conduct this use that doesn't meet the code requirement I'm assuming that you would have vetted that out before you purchased the property. That's my question.
Correct. We couldn't see the two additional CRH facilities because they're not listed on the ACA, Agency for Healthcare Administration portal, because they serve APD. So they don't serve older adults. They serve, they can serve kids 18 and plus with disability, mental retardation, and so on. So they're not listed or licensed by the Agency for Healthcare Administration. So initially when the property was bought, they actually, if you try to look it up right now, they don't pop up. So we file for on ACA portal, correct. So when we file for the zoning officer, we also don't have any children and family facility close by, just APD. So the zoning officer was the one who advised us of the APD. So we need to proceed for the variance.
Okay. And just out of curiosity, you don't check the other sites as well when you go to
Well,
ACA?
they don't have a portal. They just have a list.
And so how do you get that list?
You have to request it to the person that the zoning officer sends you the link to. So there's not a portal like ACA that you enter the address and it will pop out the facilities.
Anything else?
Jose Sanchez, and if I may add, the reason I found out of that list that she's talking about is because when I submit for zoning, they told me that I needed that list. But when I put the home address on the ACA website, like she said, nothing pop up. So that's why we move on with the property. But then when we started applying for the zoning, that's when they said that we couldn't do it because of the two ADP close by.
Gotcha. Okay. Anything else?
No questions?
Nope. I'm good. Thank you very much. All right. Is there anybody here today in support of this request? Nope. Is there any opposition to this request? Okay. I see 3 people. Have you gotten together and decided who would be the primary speaker? If not, I'm going to divide the time. Well, how much time each? 3? Okay, that's what we're going to do, 3 minutes apiece. Well, let's put 3 minutes on there. Thank you. Well, that's good.
Hi, my name is Anna Matias Rowe, and I live at 3407 West Grove Street. I'm almost directly across the street from the said property.
Right.
I have a whole packet that I'll give, and I have also supporting signatures from my neighbors opposing this ALF or CRH. Again, the Mr. Sanchez Pena is already an owner of an existing type home like this. So I would assume that there would have been more due diligence, before buying the property, whatever the circumstances. This is Grove Street is a no outlet street, as we've discussed. And yes, we do I've been there 30 years. Most of my neighbors have been there 25 plus years. We're a very, very, very close knit community. We speak on a daily basis. We have huge concerns about this facility going there. Mr. Sanchez Pena was never forthright when he purchased the property from the previous owners. As a matter of fact, he submitted a letter to the realtor saying that they had found their perfect home and submitted a wedding picture and a picture of his wife pregnant. So the previous owners, they even discussed with us, I found a perfect fit for you, only to find out when the big yellow sign came on that this was not the intent. And he also spoke with other neighbors and did not offer forthright intent of what was going on. Oh, it's about the shed. It's about this. We just wanted, right now, the only sentence that I can go on and on about being concerned about, the emergency vehicles, he proposes 6 beds, which brings 6 new families into the neighborhood.
So as I understand it, there's not 6 families that.
Well, not families, 6 people that can potentially have 6 family members visiting, workers, block driveways. When an emergency vehicle does come up, it has to go backwards. Yes, we can all have emergency vehicles come to visit our home because something can happen to us, but the likelihood of an elderly person having that happen is more likely. I just want to read that. Just one thing. The bottom line is that Mr. and Mrs. Sanchez and Miss Dolly Pena Porras, which is the actual license holder or whatever for this home. I don't think they're concerned about our neighborhood. There is a statute also. There is a statute that says, it's a Florida statute that says that a home that is located within a radius of 500 feet of an area, single-family zoning substantially alters the nature and character of the area. I think we fit in that requirement, and I just dropped off my papers.
Well, hey, first, take your time. And
Yep,
pick up
that's
your-
no problem. You know, they don't live there. They don't plan to live there. It's difficult for us to helplessly, watch our neighborhood transpose from a community, family community to a profit business community. We're close-knit, again, been there more than 25 years. Our memories are planted there. We have raised our families there. I'm raising my grandchildren there. It is our home versus his place of business. He is forcefully imposing his livelihood into our community, whether we like it or we not. We have rights too. And
So maybe explain to me the difference that you think you would see
when
from a single family residential use compared to what is being proposed.
I find that, yes, it may look like a home, but it's going to have parking. I know because there's other two homes there. We see emergency vehicles going back and forth, back from there.
Now I heard it in testimony that those uses were not the same as the use proposed here, which is assisted
They still
living.
follow the same guidelines, so there are requirements in place already. There is a reason why these guidelines are in place by the land code, development code, and by the Florida statute. If there is a code like that, why are we asking to deviate from that code? There are reasons for this. Oversaturation. He also discussed in his letter or proposal, because I just dropped everything, that it targets a different population. Area code 33614 is primarily Hispanic. He says, the Hispanic community needs this service. This zip code is already primarily Hispanic, and we have in that area, I think there's 40 ALFs in that community already. Just within our area, within a mile, less than a mile radius, there's 6 of them. And within 2 to 3 miles, or 1 to 2 miles, there's 21 of them.
And so what does that oversaturation, what is that oversaturation doing with respect to adverse impacts that worries you?
That these are residential homes. I don't want to live next to a business. I don't want, what about our property value?
Isn't the point of a 6-person living facility like this that it would be the equivalent of a residential home?
No, I don't think
Not
so.
the point?
I'm looking for a single family community home. I want to live in a community of families. I don't want to live with 6 random people across the street. I don't. When I go sell my house and I tell them I have a business across the street, I find that's going to bring my property value down. I want statistics of how this is going to make my property value go up. And I don't see any evidence or any statistics stating why my property is going to go up.
Do you believe that Florida law says that a 6-person facility like this is the equivalent of a residential home?
No, I don't believe it, but I'm going with it. But I also believe that there are restrictions and guidelines by these codes for a reason, and why we're deviating for the reason why we're here and spending man hours on something that's already been established. That's what I don't understand. So I thank you for your consideration.
And one more question for you. I know we ran up the time, but one more question for you. Grove Street, I hear a lot of zoning cases, and I just want to make sure, was there another recent application anytime in the past couple of years?
Not that I've known. No.
All right.
Yeah, and I've lived there basically all my life. I'm 30.
Okay. Thank you very much for your testimony.
Thank you.
All right. Yes, next. Morning, sir.
Hello. My name is Mike Moore. I live at 3406 West Grove Street, directly next door to the home.
If you're looking at their house, which side are you on?
I'm to the left.
Okay.
We own 3 lots on the left,
right.
And the house sits. It's one house on 3 lots. And my main thing is the fact that there's already been an exception made for the 2 houses that are the ones that are proposed, that they're already less than 1,000 feet apart. So now you're putting 3 plus 2 blocks down, there's another one. So if you look at the real map and you look at, they're all very close to each other, less than 1,000 feet. And the law says 1,000 feet separation. So I don't know why we're taking off work.
So by the way, I'm listening to you. And the law does also provide for the ability to request a variance.
I agree.
And so because of that, I have to ask you, what adverse effects do you see from the aggregation of these things that would make a difference?
I just don't want it. It's our home. All of us have lived there for over 25 years. We all know each other. We speak on a daily basis. We know what's going on with each other. And you're talking about bringing 6 adults and workers there, maybe 1 or 2 at a time. It's not fair to do that to our neighborhood. It's not.
All right. Okay, sir.
If any of you had that put next to your, would you want somebody to come in and put that right next door to your house? It's not fair. It says 1,000-foot separation, and they've already made an exception for the 2 that are less than 1,000 feet away already. So it sets a precedence where everybody can just, wherever they want to put one, they can put one. It's what it seems like it's coming to. And it's not fair to us. We bought the house where it is for the reason, and we love our homes, and it's just not fair.
Okay. Thank you for your testimony, sir.
Thank you.
And the next person? Yes, sir.
Good morning.
Good morning, sir.
My name is Alfredo Ruiz. I live just in front of the house, 3410 on Grove. And I just want to tell you that I'm against the virus. If it's accepted, that will have been living there in my home for 24 years. And I think it will change our way of living. And I'm the last house on the right side, north side of Grove, and that will change everything for us.
In what respect, sir? In what respect?
More cars. There is no access to homes. So every vehicle that will go there have to back up all the way to Lincoln. So that means 300 more feet backing up. So all vehicles that are government vehicles has a beep when they do reverse. So imagine at 2 o'clock in the morning, he said no sirens will be available, but in backing up, yeah, there will be sound. So it will change our life way of living, If Grove has access all the way to Himes, it could change everything. But in this case, I want to honor the variance that do not accept that variance. Honor the regulations that are instead right now regulating. I'm sorry I'm nervous, but my English is not
I'm getting the message.
The way it should be, but so
all right.
That's all I want to say.
Thank you for your testimony, sir.
Thank you.
Anybody else in opposition? Okay, seeing none, we'll close opposition testimony. Anything from staff?
No, sir.
Okay, the applicant has an opportunity
sir.
for a rebuttal. 5 minutes, up to 5 minutes.
Yes, Jose Sanchez.
Just out of curiosity, Mr. Sanchez, did you attempt to contact your neighbors and go talk to them about this?
I didn't see the reason why I had to do that if I'm following all the guidelines.
You just saw it, but I'm just saying.
I submit all the letters and everything that the zoning department required me to. I understand that the concern is that I may own another facility. The problem is that as it's a facility, the regulations for that one, it was in the Tampa city limits. And like I said, when we went to the ACA website, we checked, there was nothing there. We checked children and family, nothing there. And And I just find out by the zoning officer about that ADP home. They might, you guys might look at it as a business and for me to profit off. But the main reason I got into this business was because before I got into this, I used to be one of those drivers, that pick old people from the assisted living facilities. So I met a guy there, right? He worked hard all his life. He will get his check from Social Security, and basically he was homeless because he couldn't afford to pay for a nursing home or a private person that go to his house and take care of them. So by having these type of residential homes, we can accommodate people that doesn't have that kind of money to go to a nursing home.
Okay, thank you, sir. Anything else from either of you?
Thank you.
All right. With that, we'll close variance 2120. The opposition testimony is over. So with that, we'll close variance 2120.
Our final variance today is item G6, variance application 20-1369. Their applicant is Juventino and Olivia Leos. They're requesting a variance to lot development standards. Staff report was prepared by Kevin DeFrank. I will present the report at today's hearing. The applicant is requesting setback variances for a proposed single-family home on property zoned RSC 6. The Land Development Code requires a minimum front yard setback of 25 feet in the RSC 6 district. The applicant requests a 20-foot reduction to the required front yard to allow a setback of 5 feet from the north property line. Let me point out this is actually a corner lot with front yards on the north and west side. And then on the interior lot lines, it's required side yards. The Land Development Code also requires a minimum side yard setback of 7.5 feet in the RSC 6 district. The applicant requests a 2.5-foot reduction to the required side yard to allow a setback of 5 feet from the south property line. The RC district, as far as findings, the RC district requires a minimum lot size of 7,000 square feet and minimum lot width of 70 feet. Subject parcel is about 5,450 square feet in size and 50 feet in width. However, it has been certified as a legal non-conforming lot by staff. I'd also like to point out the maximum building coverage allowed in the RC district is 40%. If you look on the site plan, the building envelope that's depicted on the site plan with the setback variances will comprise approximately 56% of the lot area. However, the applicant has advised staff the size of the proposed dwelling will be approximately 1,800 square feet in size. This is a building coverage of approximately 33%. Therefore, no variance is requested to the maximum permitted building coverage. And finally, after the applicant submitted his application, he considered adding a fence height variance to this application. They submitted a revised site plan, which is in your backup, showing a 6-foot high fence, which extends into the 2 required front yards. However, the applicant ultimately decided to not include the fence variance in this request. Therefore, no variance is requested for a fence, and any fence installed on this property will be limited to a maximum height of 4 feet within the required 25-foot front yards on the subject property.
Okay, thank you, Tom. And the applicant, please. Yes, sir. Good morning.
Morning, my name is Juventino Leos, 910 Lewis Place, Logan, Florida, 32750. Can we see this? Basically,
there you go. Run it down a little bit more. Down.
Down
Yep.
there.
Very good.
Basically, you can see the north side, I got 25 feet of setback. And I wish to have at least 5, which is similar to my neighbors. That's plus the other 5 feet on the back, which is already 7.6. So it's not that complicated. That's what I request.
Okay. Thank you, sir. Appreciate the testimony. All right. Anybody here today in support of this request?
Thank you.
Seeing none, is there any opposition to the request? Tom, anything else from staff?
No, sir.
That will close variance 201369.
That concludes the variance portion of our agenda. It now takes us into section H, special uses. For special uses, item H1, special use application 20-1190. The applicant is Jerk Pit LLC. They are requesting a 2 COP alcoholic beverage permit, which requires a distance separation waiver. Staff report was prepared by Steve Beachy. However, I'll present the report and staff a recommendation following the applicant's presentation.
Okay.
Hi.
Good afternoon.
I haven't been sworn in.
Oh, okay. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Hi, my name is Dixie Liberty. I'm at 13359 Ashbart Court, Riverview, Florida. I'm here today on behalf of Jerk Pit LLC, location at 1939 East Fletcher Avenue in Tampa, requesting a 2 COP beer wine on and off premises. The building contains 928 feet. The Jerk Pit has been there for many years. The clients have grown and they've been asking for beer and wine at the location. I'm asking for 2 waivers. The one waiver is for the residential within 250 feet. The restaurant faces the north of the duplexes that sits in the back behind the south. There is a pond that separates from the building, a pond, and then the duplexes, which it also has a fence and some shrubs that block the area. There is a sidewalk, but it only goes down partial of the way to go to the duplex, and it stops. It's 169 feet. The second is the second waiver is for 3 of the same of kind within 1,000 feet. There are several alcohol beverages in the area that sits in the Fletcher Avenue area. It's all commercial that's through the area anymore. You have any questions?
I don't, but thank you for that. Okay. Tom, when you go to address this, you're going to do this.
Yes, sir.
So if you notice on page 2 of the staff report, the bottom, it's just a Scrivener error, I think. They left the old 4 COPRX.
Oh, yes, sir. We'll correct that.
And then right below that, there's a code site and it's D.4. And I think that's supposed to be D.5.
Okay, we'll check that, sir.
And so that I don't belabor this, we'll get to another one here in the near future. Same exact thing was done because it was a template, kind of thing. I'll point out when I get there, but go ahead.
Okay. Apologize for those errors.
Yep.
I think the applicant has sufficiently addressed the nature of the request and the separation requirements and the 2 waivers. Therefore, I'll just concentrate on our staff findings recommendation. The Land Development Code provides for approval of separation waivers where there are special or unique circumstances where the alcoholic beverage use applied for does not have significant impacts on surrounding land uses, and there are certain circumstances which negate the necessity for the specified distance requirement. With regards to the waiver sought for the number of other wet zonings within 1,000 feet, staff finds that the proposed wet zoning is located on an intensive commercial corridor, Fletcher Avenue, with a large number of approved wet zonings of the specified types within 1,000 feet. However, only 2 of the specified wet zonings are located on the south side of Fletcher Avenue with the proposed wet zoning. The remainder are located on the north side of Fletcher Avenue, which is a 4-lane divided roadway with 80-foot wide right-of-way at this location, thereby mitigating the cumulative impact of the total number of wet zonings within 1,000 feet. Then as far as the separation waiver from the residential property to the south, the building in which the proposed wet zoning will be located is oriented away from the residential property south. Additionally, the normal route of travel by foot or vehicle from the proposed wet zoning to the nearest residential unit is approximately 360 feet. For these reasons, staff finds the proposed wet zoning does not propose significant impacts on surrounding land uses, and the necessity for the specified distance separation requirements is negated by the circumstances identified above. Therefore, we recommend approval of the 2-cop wet zoning based on the survey submitted on August 31st.
Okay, thank you for that. Anybody here today in support of this request? I see none. Is there any opposition to the request? Nope. Ms. Liberty, anything else?
No, sir.
All right, with that, we'll close.
Sir, you said you had something else to identify in the report, Scrivener, sir?
There's two the same.
Those two?
Yeah.
Okay.
I'll explain it. So don't worry about it for right now.
Okay, great.
I'll show you one minute. And me, you. With that, we'll close special use 20-1190.
Item H2 had been continued at the start of the hearing to the January 25th, 2021 Lujo hearing. Takes us to item H3. This is a special use application 20-1376. The applicant is Jerry T. Shaw. The request is for a 4 COP RX alcoholic beverage permit, which requires a separation waiver. We have a revised staff report to submit. Most of the changes, and they'll be handed in right now. Most of the changes you find are in regards to the existing wet zoning on the property that's going to be obviated by the proposed wet zoning if approved.
Got it.
Tanya Chapella will present the report and recommendation following the applicant's presentation.
Okay.
The request is for a distance separation waiver for a proposed 4 COP RX alcoholic beverage permit to allow for the sale and consumption of beer, wine, and liquor on the permitted premises only in connection with a restaurant. I'm sorry, my name is Tanya Chapella, Development Services. The proposed wet zoning is located in an existing restaurant at 18430 Livingston Avenue in Lutz. The proposed property is on CN. The wet zone area will comprise a total footprint of 6,628 square feet, as shown on the revised wet zone survey received December 9, 2020. The applicant is requesting the wet zoning to expand the existing restaurant on the property to include a second and next dining building. The existing restaurant building has a 2 COPR wet zoning, SUAB 17.
Tanya, I'm sorry. On special uses, the applicant goes first, sir.
Oh, I'm sorry.
That's okay. All right. Okay. I'm sorry. That's fine. Yep. Go ahead, Tanya.
So the existing restaurant building has a 2 COPR wet zoning, special use AB 17-0440, which allows the sale and consumption of beer and wine on and off the permitted premises in connection with a restaurant. It was approved for a 2,475 square foot area, including a 540 square feet of outside seating area. The proposed wet zone 4 COP RX will permit the sale and consumption of beer, wine, and liquor on the permitted premises in connection with a restaurant. At least 51% of total biannual sales must be derived from the sale of food and non-alcoholic beverages. Additionally, the restaurant must have at least 2,500 square feet of gross floor capacity, gross floor area, and covered patio area, and 100 patron seats. According to the site plan submitted by the applicant, the existing restaurant building has 2,500 square feet of gross area, indoor and outdoor, and 80 patron seats, while the annex dining building will have 2,095 square feet of gross area and 25 seats. So the separation requirements will be as follows. So for the proposed 4 COP RX, wet zonings must be located at least 500 feet from specified community uses and 150 feet from residentially zoned properties. For the submitted survey, There are no specified community uses within 500 feet of the proposed wet zoning. However, there is a residentially zoned property, RSC2, within 139 feet. The applicant requests an 11-foot distance waiver from residentially zoned property to allow a separation of 139 feet and has provided the following justification. There are no residential structures on the affected parcel, only a shed. So now I'll present the staff findings. So in view of the site's existing 2 COPR wet zoning, the proposed 4 COPR wet zoning represents a marginal increase in the intensity of the use. The primary restaurant building is approximately 180 feet from the residentially zoned property. Additionally, the rear of the annex dining building faces the residentially zoned property, and the normal route of travel from the front entrance to the annex building to the residentially zoned property is approximately 250 feet. Furthermore, it appears from online imaging that the sidewalk adjacent to the restaurant on Livingston Avenue does not extend southward to the residentially zoned property. So per the property appraiser's information, the residentially zoned property is presently vacant except for a shed. So if developed with a single family home, the likely location of the dwelling will be more than 150 feet from the proposed wet zoning. The proposed wet zone footprint includes the outdoor area between the primary restaurant building and the annex building, and is crossed by the driveway serving the site. Therefore, staff recommends that the sale, service, and consumption of alcoholic beverage be limited to the seating areas identified on the submitted site plan. The site plan submitted with the subject application was not reviewed for site development compliance and approval of the proposed wet zoning. If granted, does not guarantee or imply site development approval. For the reasons discussed above, staff finds the proposed wet zoning approvable subject to the following conditions. 1, sale, service, and consumption of alcoholic beverage shall be limited to the 2 building areas, totaling 4,595 square feet of indoor and outdoor area, shown on the site plan received December 9, 2020. The second condition is upon approval of special use AB 20-1376, the existing 2 COPR wet zoning on this site, SU AB 17-0440, shall be rescinded. So the approval is based upon the revised wet zone survey reflecting a total wet zone footprint of 6,628 square feet total area and received December 9, 2020. This concludes my presentation.
Okay, thank you very much for that. And the applicant, please.
Good afternoon, Mr. Hearing Officer, Mr. Hisney, and thank you, Ms. Capella, for that report and recommendation. My name for the record is Bruce Landis, agent for the applicant. I was not in here earlier for the swearing. So
okay, please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. So for the record, my name is Bruce Landis. My business address is 3810 Northdale Boulevard, Suite 100, Tampa, Florida, 33624. Thank you for this opportunity to present our application to you. We are requesting a special use alcoholic beverage permit for COPRX with a distance waiver. This is for the property with folio number 33622.0000. The address is 18430 Livingston Avenue. This is an AB zoning to encompass an existing restaurant, and as Ms. Capella mentioned, had the 2 COPX designation on there. The zoning for the parcel itself, the larger parcel itself, is 1.57 acres. It's zoned CN, and it's been operating as a restaurant store offices, shopping center area for decades in that area. The property has had a wet zoning through Hillsborough County for almost a decade, and as far as we can tell, the records, there's not been any zoning citations for the property. The most recent wet zoning approval was in 2017 for the 2 COPR that encompassed the existing restaurant structure. Our 4 COPRX request is really essential to the survival of Mr. Shaw, the applicant's restaurant in this area, and really enable it to be competitive with the massive amount of restaurants that have been happening up in Pasco County. This development has been serving the community as a neighborhood commercial area for decades and is very compatible and consistent with the consisting area, and is very loved by the residents in that area for its convenience and its character. In obviously recent times, the restaurant suffered greatly because of the impacts of COVID-19, and we do have a need for larger dining space to safely serve the patrons. And so your granting of these 2 requests, the designation and the distance waiver, will enable the restaurant to survive these challenging times. So the 2 requests that we do have for you, and let me show the area map, vicinity map. So this is the CN zoned property. This is Sunset Lane, Livingston. North is this direction. And so the existing restaurant is right there, and we'll be using an annex. We propose to use an annex dining in an existing commercial building just right adjoining it across the drive, the entrance drive. So our request is for a 4 COPRX, beer, wine, and liquor, for sale and consumption on the permitted premises, only in connection with the restaurant operations. The request meets the seating and square footage requirements, as Ms. Capella mentioned in her staff report, for 4 COPRX, according to section 6.11.11 of the Land Development Code. And those requirements are for a minimum of 100 seats and a minimum of 2,500 square feet of gross floor capacity. We're proposing, with use of the annex dining area, a total of 105 seats and a total square footage of about 4,600 square feet, 46,595 square feet to be exact, including the existing covered patio in the existing restaurant and the covered patio in the annex area. Let me show you the site plan so you can get a little orientation as to our operations. So this is a zoom in on the property. This is the location of the existing restaurant, the area that has the existing AB zoning. And then we have the annex area, the dining area here, that will be converted over to dining. And so both areas do have a relaxed suburban rural dining experience with adjacent and adjoining wraparound porch and dining areas. And just to illustrate, this is the view from the annex dining area, looking towards the porch and the existing restaurant in that area. Part of the allure and one of the reasons the community likes this area is the applicant, owner of the property, did a very fine job in preserving the natural vegetation in that area. So it's a very well shaded area, very fits in, very well fits in with the community. Our alcoholic beverages sales will not exceed 49% in compliance with section 611.11. Current percentage of sales are much lower than that. The second thing we're requesting as part of this is a distance waiver. And as Ms. Capella indicated, there are 3 distance requirements for this AB zoning type. The distance requirement to certain community uses shall be at least 500 feet. There should be no more than 3 AB establishments within 1,000 feet of the proposed wet zoning. And the distance requirement from a residentially zoned property shall be 150 feet. We meet the first and the second distance requirements in their entirety, but the envelope does touch and is a little slightly less than 150-foot distance requirement. And I'll show you the AB survey so that you can understand the orientation of the distances. So again, here is the area where the restaurant and the dining will be, and the closest residentially zoned property is this zigzag shaped parcel here, and you can see this corner is 139 feet away from this area, and this is to the rear of the of our development. And this single parcel here, as you heard in the staff report, is vacant with the exception of an existing shed. Also, if you were to be right close to that corner on our property, looking towards that corner, you would see that it is well screened and buffered from, make sure I can get this oriented. You see that it's well screened and well buffered by a 6-foot wood fence on our property, and also the extensive landscaping and vegetation in that area. So we believe that the waiver of that, especially is from this parcel, is especially justified in terms of its buffering. So as staff indicated, through visual inspection and from the road and from the Hillsborough County Property Appraiser's website, there are no residential structures, only a shed. We intend to ensure the public purposes of the distance requirement will be met by maintaining that fence and that vegetation that you saw there. And in conclusion, we would submit to you that our request is compliant with the Land Development Code and its provisions. Our restaurant is promoting the lifestyle that's cherished and loved in that community. Your granting of the AB designation and the waiver will continue to allow us to provide the residents in that neighborhood with a convenient local dining option in that area. And then also, I do have letters of support from adjoining property owners. I don't know if you want those submitted now or wait until the...
Let's go ahead and give them the clerk when you're all done and you go to sign in.
Okay. And so the 2 letters I do have are... just to show you the location that I submit is... This is from the owner of this property here to the south, and the other letter of support is from this property owner to the north.
Great.
So that's what I have at this point.
Mr. Landis, the only question I have is, did you get an opportunity to look at the revised staff report at all?
I'm sorry?
Did you get an opportunity to look at the revised staff report at all?
No, I didn't, but the articulated conditions is something we are in agreement with.
So you have read the recommended conditions. Why don't you take a quick look? I want to make sure.
Okay, thank you. Yes, that represents what I heard her say, and so we're agreeable to those.
Okay. Thank you for your testimony.
Thank you.
All All right. And is there anybody here today that needs to speak in support of this request? Seeing none. Tom, anything else from staff?
Just real quickly, yeah, the condition in general form had been discussed with the applicant prior to today. And then the revisions that were made with just some clarification on the areas. But again, it had been discussed with them and it had actually been contained in the original staff report. So, right.
Thank you for that. All right. Mr. Landis, anything else before I close it?
No, Your Honor. Thank you very much.
Thanks. And we'll close special use 2013-76.
All right, our final case today is item H4, special use application 21-0021. The applicant is Lodvid Wines LLC. The request is for a 2 COP alcoholic beverage permit, which requires a distance separation waiver. Steve Beachy prepared the staff report. However, I will present the report and staff recommendation following the applicant's presentation.
Thank you, Mr. Hearmaster. Good morning.
I got to say, Mike, I know that the world must be in order somehow, some way for you to be the last petition today. Because as I recall it would have been Tom Hisney in the early 90s and you as well.
That's right. Well, this is a trip down memory lane here, right?
Go ahead.
I remember,
I'm sorry.
That's all right. I remember hearings going to 2 in the morning in the old days. A pleasure. Michael Warner, 14502 North Dale Mabry Highway, representing Lodvid Wines. I will be brief. We are the last case. We have no opposition. We already have a 2 APS, Mr. Scroll. This was granted about 45 days ago. My client just opened up, so able to sell on the retail side and very excited to do so. They are now asking for the COP to allow this bar to actually have people consume beer and wine on site. We have worked with staff. We appreciate Mr. Beachy's findings. This was granted on the APS, I believe, October 6th of 2020 under AB 2013-19. This is part of a large PD in Carrollwood, 1978, OC 20 in the comp plan. You probably noticed the address of this is 14610. My address is 14502. I'm not saying I have a vested interest in this application, but it's 120 feet from my office front door. And I did purchase my first bottle of Cabernet from this establishment recently. If I can just show you the orientation. Whoops, that's not good. So here's the center. I'm Scroll Dale Mabry, very familiar to the east. This is a corner location that essentially faces southeast. My office front door is right here, just to the south. Some shots inside. This is the outside parking lot. There we go. Very hard to see. They are now getting their sign posted by the contractor, I believe, middle or end of this week, which would certainly help because it's very difficult to see right now. Parking lot facing due east to North Dale Mabry Highway. Internal location, they just laid the hardwood floors. They now have the painting in place, the wall panels, the lighting. They're now starting to get the inventory. Again, the display's in place. Other display cases internal to the bar. Victor waiting for his first customer, which was me on Saturday. So a very high-end, upscale wine bar, and we appreciate your time. I only have one waiver request for this, and that's because of the number of establishments greater than 3 within a 1,000-foot radius. We have no other uses within the 500-foot community use or the 250-foot residential. However, Dale Mabry corridor is replete with neighborhood bars, wine bars, and restaurants. This is not unusual. We have 9, I think, of the 20 that require that notice provision. We are number 20 on all ABs to give you an idea of the Carrollwood character on North Dale Mabry arterial highway for these types of uses. Certainly not unusual. Wetlands to the west, wetlands to the north, and certainly appropriate compatible. That's all I have. Thank you, sir.
Okay, thank you, Mr. Horner. Anybody here today in support of this request? Is there any opposition to the request? Okay, with that, we'll close special use.
Mr. Scrolla,
yes,
if I may, and I apologize. because of the time constraint with the holidays, this is not a request, it's just a courtesy. If there is any way that we could have an accelerated.
The main issue will be transcripts. It always is.
Correct.
So the question is whether I can get them. The pandemic has tended to slow things down.
Understood.
That leaves very little time, you realize, because it's at the earliest, it would typically be Monday. And that's getting right before Christmas.
Understood.
So
I'm only offering, if you can accommodate, wonderful. If not, we certainly understand. You have a lot of cases, and those filing requirements and those delays are part of that process. So,
Carmen, you don't know anything better than I do about it, do you? Okay. Well, let's press wherever we have to press and see what we can get. But otherwise, we'll have to see how it rolls.
I understand, and thank you so much.
Thank you very much, Tom. Anything before I close it?
I haven't done a presentation yet. It'll be brief. No problem. It'll be very brief, sir. First of all, I apologize once again. There is a scrivener's error in the middle of the report about the type of.
That's what I was referring to.
Yes, sir. We'll take care of that, and I apologize for that. Applicant more than adequately summarized the one waiver that's needed. So as far as staff findings and recommendation, the Land Development Code provides for approval of separation waivers where there are special unique circumstances where the alcoholic beverage use that's applied for does not have significant impacts on surrounding land uses, and there are certain circumstances which negate the necessity of the specified distance requirement. We concur with the applicant's basis for the waivers, and we find that the proposed AB uses can compatible and consistent with the highly commercialized character of Dale Mabry Highway and the vicinity. I'd also like to add to the report that of the other wet zonings within the certain types of wet zoning within 1,000 feet, several are on the other side of North Dale Mabry. Others are to the south of this site in a separate shopping center, and there is an intervening shopping center between this proposed use. And so we find that that's also going to mitigate the cumulative impacts of the number of wet zonings within 1,000 feet. And finally, the proposed 2-cop wet zoning will replace the existing 2 APS wet zoning, and therefore represents an incremental intensity of the AB use.
Okay, thank you for that, Tom. Mike, anything to add to that?
No, sir. Thank you.
All right, with that, we'll close special use 210021. I think that will do it for our hearing today, and thanks everybody for your help.